Hello, everyone. Welcome to the Arbitration channel. My name is Lauro Parente, and today we continue a series of interviews with the big names in international arbitration. These interviews are conducted by Mauricio Gomm. Mauricio is a GST LLP partner in international arbitration. The Arbitration channel is a think tank that discusses alternative dispute resolution methods focused in arbitration. And this work is made possible by our sponsors who support our initiatives. Now, we're going to take the floor to Mauricio. Hello, Mauricio.
Good morning, good afternoon, and good evening. We are going to start another conversation hosted and organized by Canal Arbitragem, who is run by Lauro Parente. Lauro Parente, thank you very much for organizing and hosting this event, this conversation with my dear friend Yves Derains. Yves Derains is what we can say without any doubt is one of the luminaries of international arbitration for so many years. Yves Derains is well known for the entire international community, but I would like to highlight some of his qualities based on his CV. Yves Derains is a founding partner of Derains Garavi, and he is ranked in many top international arbitration vehicles, such as the Chambers, and this year he is ranked as thought leader global elite by Who is Who Legal. Yves Derains, he led the review of the ICC rules of arbitration adopted in 1998 and participated in the review of new rules in force of January 2012, and of course, the latest one, 2021. He is the co-author of many publications devoted to international arbitration, and he is the co-author of the seminal test on the application and interpretation of the ICC rules of arbitration. He's a quite experienced arbitrator and counsel. I have the pleasure, honor, and personal satisfaction to have this informal conversation and chat with Yves Derains on issues regarding arbitration, international arbitration, and investment state arbitration. So, Yves, thank you very much for your time, for us to discuss a little bit of arbitration today. If I may, let's start from the who, why, where, and when. So if I may, how, when, where, and why did you start your career in international arbitration?
Well, first, thank you, Mauricio, to invite me to discuss arbitration. As you know, that's one of my favorite themes, and to discuss with you is really interesting due to your experience and your interest in this matter. Why? Well, as many things, it's a result of hazard. In fact, I was in my post-graduation, I have chosen comparative law. And this specific year, the theme chosen by a great French comparatist, Professor René David, has chosen as a theme arbitration in comparative law. I didn't know anything about arbitration, but I was fascinated. Then I had to leave the university to do my military service, which was still mandatory in France at the time. And I did that in Tunis. And in Tunis, in the small library of the law of the law of the University of Law, I found the thesis of Philippe Fouchard on international commercial arbitration. And I took it from the library and kept it 1 year and read it and read it and read it. And when I come back to Paris, I decided that I wanted to work in arbitration. It was a very different time. Few people were interested in arbitration. I went to the ICC. I asked whether they had a job. And I had a discussion with the then Secretary General of the ICC Court of Arbitration, Frédéric Eisemann, who was looking for somebody. And we had a 1 hour discussion, and I was recruited just like that. And this was the start. I stayed 10 years in the ICC, and leaving the ICC, I entered really in the career of arbitrator and counsel in arbitration.
Interesting. You've mentioned, Yves, that was very different. And I agree with you. It was very different back then. Can you just tell us a little bit how different, not only quantitative speaking, but how different was arbitration back then?
I think it was completely different because few people were interested in arbitration. Few people were keen to be involved in arbitration. And so it was a sort of a club of people who had a passion for arbitration. And it was not at all popular. I think the best example, when I left the ICC as Secretary General of the ICC Court of Arbitration, no law firm wanted me. Today, the Secretary General of the Court will find a lot of law firms interested by his profile. No, it was not possible. And that's the reason why I, with a friend, Paul Gélinas, we just start up our office, but not because we really wanted to do it, because nobody wanted me. All the big law firms that I saw said, well, we have an arbitration or 2 per year. We are not prepared to recruit somebody like you. So I had to go alone, not alone, but with Paul Gélinas. So
interesting.
The climate was, and this was in 1981.
Mm-hmm.
It was completely different.
Yeah, 40 years ago.
Exactly.
During this time frame, Yves, especially now regarding the ICC or the development of the ICC arbitration, how do you see this or the changes to the rules, changes to the ICC during the last 4 decades? And if you can, how do you see the rules today vis-a-vis the rules yesterday, if I may say so? And is this a sort of an answer to the users? Is it an answer to what's happening in the world of arbitration? So how can you define where we stand today, especially on the ICC arbitration?
Well, I think, yes, it is. The evolution is an answer to the needs of the users. The rules are more detailed. They are controlling more carefully the work of the arbitrators. There is a certain pressure on the arbitrators to try to make them work rapidly, to have more dedication. There is also, I would say, more knowledge of the procedural issues by arbitrators and by the institution than at the time. And now there is, I think, let's say, a global international arbitration procedure which is applied with some nuances, differences, but in general terms, more or less everywhere, which was not the case when I started. If you had, in this period, if you had a case between, let's say, a French company and a German company, you would have no disclosure of documents, nothing like that. It was the civil procedural law type which was applied. Now we are not in this situation. We have really a global system which can be criticized for many reasons, but which is completely different and which have also some advantages.
Yeah, yeah. This is interesting, Yves, and I can see in your CV that you were the co-chairman of the ICC working group on the reduction of costs and time in international arbitration. So this, to me, is a topic that was, has been, is, and will be a hot topic, especially for the arbitral institutions, how to reduce time and costs for the users of arbitration. How can we cope, or how can we set up this intention, this goal of reduction costs and specifically time, with some concerns regarding due process in arbitration?
Yes, I think that's a big challenge for what I call the arbitration community. I personally think that one of the problems of this global arbitration procedure that I have just referred to is that at some time in the 80s, there has been a trend to try to create a new type of procedure, which would be a sort of a syncretism between the common law tradition and the civil law tradition. And this did not work correctly, because instead of being a syncretism, it was more a duplication of both procedures. If you look at the typical arbitration procedure which is followed now internationally, you have first an exchange of memorials with all the available evidence. This is typical civil law. Then you have a period of disclosure of documents. Then you have again, let's say in the straightforward cases, you have a new exchange of memorials with all documentation available. Then you have a long, rather long hearing, post-hearing brief. So you have both aspects at the same time. And the hearing is typical common law and not civil law. And the problem is not just this duplication, it is also that from the beginning until the end, each party is telling a story. And this story is the same, it is developed slowly, but how does that start? You have a man, let's say the president of a company, of the general counsel of a company, go to see a lawyer, tells the story to the lawyer writes the story in a memorial. On the other side, they do exactly the same thing. You have various witness statements, which are, again, the same story, but in small parts. That's a sort of a declination of the story. Then during the hearing, the witnesses repeat the same thing. And one of the cause, I think, among all this, of the cost and time of the arbitration is that there is no focus on the important issue to be resolved. Most lawyers in international arbitration are not using documents or witnesses to prove discussed issues, but just to support their story. And they cover everything without knowing whether it is important or not. And I think that's here that something should be done. What I am suggesting, with some success, but not such a big success, is that at some point, the arbitrators and the party have a discussion about what is the case, what are the issues to be resolved, but not as it was done in the past in the terms of reference, where you had a list of issues to be resolved. Now you don't have it, or when you have it, they are completely artificial. Was the termination justified, or things like that, which doesn't help at all. I think what should be done is that the arbitrators tell the party, well, that's the way I see your case, without saying what they think of the solution, but these are the problems. Do you agree? And the party should say, well, we agree, we don't agree, because the arbitrators may be wrong. And then it is possible to focus on the real issue, and you will limit the number of witnesses, the number of production of documents submitted. For instance, why to let's say in a construction case, what would you submit all the documents of the works if you have just 3 or 4 aspects of the works to be discussed? But now you have 1,000 pages which are submitted that nobody reads. So I think this is the way to approach the thing, but it is difficult because first, parties are afraid that the arbitrators may prejudge the case. And another aspect is that it obliges the arbitrators to work very early on the case, and they don't do that right now. Not all, but many arbitrators wait until 2 weeks before the hearing to really read everything, work to be prepared for the hearing, but they don't intervene on substantial issue first. So I think it is in that direction, but there is a lot of reflection to be done, because the existing system is working. It's costly, it's very long. It should not be just destroyed because some people have new ideas. But I think these new ideas has to be really considered and implement and probably worked.
Interesting. Yes, your reflections are your inputs, insights. They are very important. And I took some notes here, Yves, when you were speaking. So it creates some sort of a couple of follow-up questions on this. For example, when we see today, the world of international arbitration is not just, as you said, sort of a gentleman's club. It is, so there are many new players coming from all over the world, different jurisdictions, different systems of law, different ways people learn how to be a lawyer. And they are bringing to the international arbitration some, I would say, some flavors, some different flavors, some habits, some ways of doing things under their own domestic litigation or even domestic arbitration. So this is something that adds a little bit the challenge for the arbitrator or the arbitral tribunal, with this amalgama of different players in terms of knowledge, experience, apart from cultural and different legal system. So we can see, for example, in terms of time, Redfern schedule. So I've seen recently huge Redfern schedule, which takes, so, and then, as you said, so they are just jotting down many requests and documents, etc. So let me ask, if I may, 2 questions on this. You can add whatever comment you want on these issues, but you've mentioned common law and civil law. Today, we tend to say that there is no more thing of common law or civil law, but an experienced or unexperienced counsel or experienced and unexperienced arbitrator. But yet, I can see with those comments I've just made that arbitrators and counsel, they are bringing consciously or unconsciously what they are used to. So, do you see a sort of a denominator for a good international arbitration, where the arbitrator can see, I can see people are coming from different jurisdictions, so let me try to use some sort of common ground. Of course, we have those IBA guidelines and rules, etc. But how do you, when you set up, for example, a status conference, you set up a hearing or a pre-hearing, or in the middle of the case, a meeting to discuss, or sort of to, as we say, presentation of case, to define exactly what the issues are. With this, when the players are so different, or not only the players are different, but the experience is different too. How can you just draw the line in order to not to show some sort of the impression one of the parties think there is a sort of a predisposition from one side to another?
That's very difficult, and that's really the challenge, to be, on the one hand, able to help the parties to focus on the issue without showing an inclination toward a direction or another, and in particular because when you are at the beginning of the case, or even more, 1/3 of the case, I would say, you may understand things incorrectly. That's the great danger. What I try to do is to prepare for the party a report with my colleagues of the tribunal, saying that the way we understand the case, and we think these are the important issue, and ask the party to comment that before the midstream conference. And often the party will correct the arbitrator. The arbitrator must be very, very modest. The worst arbitrator, I think, is arbitrator who has made up his mind or her mind just at the beginning of the case. I remember a former president of the Supreme Court in France who was arbitrator. And once he told me, well, I understand your case. You want this, you want that. And the other side, you want this? No, I told him, Mr. President, it's not exactly like that. Yes, I know these cases, I have understood. What can you do? That's terrible. So you must be very modest, show to the party that you are trying to understand, and that you don't want to impose any view. But you have to be very prudent. I think you should never mention what could be a solution, just indicated what are the problems that you see, and then let the parties deduct what they have to do to resolve these problems. But as you said also rightly, it's not just a problem of the jurisdiction each party or each counsel, I would say more, come from, but the level of experience. Because people with experience in international arbitration, they are able to adapt to the specificities of each case. People who have experience just in their own jurisdiction, it will be very difficult for them. And here I think the arbitrators have the responsibility to explain them what are the rules. Let's take the example of the witnesses. In the common law tradition, anybody may be a witness, even the party may be a witness. In many civil law countries, this is just impossible. So if you just tell the party, well, by such date, you may present a witness statement, it is possible that the civil law counsel with no experience in international arbitration will believe that he can only submit witness statement from person who have no relation of dependence with the party. You have to explain this thing. Well, you don't know. You don't have to do it if you know who are the counsel, if you know their experience. But sometimes you have to consider the thing differently. You have also to explain to civil law lawyers the concept of disclosure of documents. That because the reaction, well, I'm not here to help the other side to prove its case. And you explain that the idea is that each party is entitled to have access to the document of the case. It's not a problem of burden of proof. The burden of proof comes only when there is no document, when there is no proof. It is on the basis of the rule of burden of proof that you may resolve the case. Here is just a problem of giving equal access to both parties to the documents of the case. But then you have to explain to the common law lawyer that this access should be limited to documents which are material for the solution of the dispute and not any document. And here you have a different type of education to make. So it's not an easy job to be an arbitrator. That's
It is
fascinating.
not. It is not. I entirely agree. It is not an easy task, but it's a learning process. And I always say that I learn a lot of things in all cases. In every case I sit as arbitrator, it is a learning process. It is, as you said, it is a fascinating experience. You've mentioned witnesses, written statements, so I would have many questions more on those two issues. But let me ask you, since we are talking about cultural, different legal tradition and experience, tell us a little bit the life, if you can, the life inside the arbitral tribunal. When you face or when you see a co-arbitrator who is not very well familiar with arbitration, or he or she may be not even a lawyer. So when he or she brings this, how do you, especially on the procedural orders, not so much on the award, which of course can be, we can see dissenting opinions, but dissenting opinion on procedural order is always something challenging. But how can you, inside the tribunal, is there any thought, any input, any reflection that you'd like to make?
Well, I think it depends very much of the independence of the arbitrator, because fortunately I see arbitrators to be more and more independent, really more than when I started to be an arbitrator. But let's take the exception. If the arbitrator is not independent, it's not very easy to convince this arbitrator, because it's not a problem of discussion, it's more a problem to be able to impose something. But I may tell you that in my life, I've never seen a procedural order rendered by majority. So I know it exists, but it is very, very rare. Now, if you have an independent arbitrator who just does not understand the issue because he has no experience, Well, you have to explain, you have to discuss with him, to show him that what you are suggesting to decide is for the benefit of everybody. That's what is very important. You have from the beginning to try to create a relation of trust among the tribunal. That's probably one of the more important things that you have to do, because if you succeed doing that, then you can convince somebody who has no experience. But
Yes,
there is no two cases which are the same in this regard. So
yeah, yes,
because
yes, I agree.
you have the unexperienced arbitrator who is working, you have the unexperienced arbitrator who is not working. It's not the same discussion that you have. So it's not, there is no general rule.
Yes, yes, I agree. I agree. And also, this is also very interesting topic. Um, uh, you've mentioned the element of trust. The arbitrator has to build up trust, and this is, I would say, the mediator as well, and adjudicator, etc. What is, in your opinion, the most important characteristic or characteristics of a good international arbitrator?
Well, several, I would say. Well, first, and I shall leave that immediately, he must be an arbitrator. I mean, it must be somebody impartial and independent. Otherwise, he is not an arbitrator. But this is not enough. That's a primary condition. Then the qualities, I would think that the first quality is the ability to decide. The worst arbitrator is probably the arbitrator who cannot decide rapidly. And I'm not talking about the time to write an award. I'm thinking of the arbitrator who has to make up his mind because there are a lot of incidents in the procedure. That's even more significant during the hearing when you are you are controlling the conduct of the examination of witnesses. You have a lot of objections. You have to decide immediately. And what the parties expect is that if there is an objection, you accept it or you dismiss it, but you don't enter in long consideration. And I think that is very important, because if, for instance, in a three-member tribunal, the arbitrators withdraw to discuss each time there is an objection, you cannot conduct a hearing. So you must be able to decide rapidly. Probably it needs a certain experience to do that, but that's very important. I think the second quality is the ability to generate that trust that we were discussing. It's not just a trust among the arbitrators, but it's also to have the trust of the parties. This is very important. And I would say that to obtain that trust, the worst thing for an arbitrator would be to try to please everybody. For instance, I've seen arbitrators, if during the examination of witnesses, they dismiss an objection made by one party, they will tend to dismiss an objection made by the other side. And when you do that, you displease everybody, because nobody considers that your decision is just. So you have to be trusted, but you have to follow the rules as they are understood by everybody. I think the third question that we have discussed, the third quality, we have already discussed that, is what I call the cultural neutrality. You must try, because it's not so easy, but you must try to show that you understand the legal cultural differences between the parties, and that you recognize them, and you try to do what you can to take them into consideration. And when I mean cultural neutrality, I don't want to say that the arbitrator should endeavor to know all the procedural law of the world, something like that. No, but just to be aware that there are differences, to be aware that your own national procedure is not a universal procedure, that it's not just natural law, as for instance did this English arbitrator, Lord Asquith of, I don't remember his name exactly, but in the 50s, he said that the contract was governed, I think, by Saudi law, but he said, well, Saudi law have not been proved, so we will apply English law because it is equal to natural law. I think this is an extreme, it will not exist today. But that's very important. It is even maybe more dangerous, this approach, when you are in your own legal tradition. Many civil law arbitrators, for instance, I will say French arbitrators, will think that, well, all the civil laws are more or less as French law. Obviously, it's not the case. So you have to be aware that differences exist, not to follow you what you have in your bag and baggages. That's important. Another important quality is to be a correct administrator. I think you should be able to administer a case. That here you have the problem of the help of arbitral secretaries, and I think that's very important. But if you have an arbitral secretary, you have to be able to choose the person and to make that person work correctly. And the last point I would say is the availability, because if you are not available, you may have all the qualities of the world, they will not be perceived by anybody.
Thank you, Yves. This is amazing. I think that many people will very much enjoy thinking, reflecting what you've just said. Let me try to combine two of those characteristics, important characteristics that you've just mentioned. One is the ability to decide, and the other one is availability. Not because the others are not important, they are so fundamental, but just for the sake of some sort of going to ask a question based on these two, the combination of these two. Ability to decide. I think this is something that you have to have knowledge, experience, etc., but devotion of time. And this, the counter part of this is what we see, the due process paranoia, because you don't know exactly how to deal because of lack of devotion, lack of focus, lack of time on the issue. And then you tend to, as you said, tend to please both parties, when at the end of the day, you end up unpleasing both them. This goes to devotion of time, and this goes to availability. Is there, and this is something that has been subject of many discussions in Brazil today, there is even a bill that is to be discussed before the parliament to limit it, the amount of cases the arbitrator should have. What is your opinion of this, or what is the right amount of cases an arbitrator can handle? Is this something that there is no way we can draw an average because it depends on the arbitrator himself or herself? Is this something that we can see, or it varies from professional to professional, varies from arbitrator to arbitrator? One is quicker than the other, etc. Is there any thought, any input on this topic?
That's very difficult, because obviously I think an arbitrator cannot have 50 cases at the same time. That I think it's probably not possible. But then to fix an exact figure, it's very difficult, because it depends on each arbitrator. what is doing this. For instance, let's take an arbitrator who is a law professor who has to go to the university a number of days per week. It's obviously he cannot take as many arbitration as somebody who is just doing arbitration. So you have to see what is the activity of the person. That's one aspect. You have also the organization of each person. If the arbitrator has a little team with him, working with him, he can take more cases than somebody who is absolutely alone. I think that what the ICC is doing presently, asking the arbitrators what are the days where they cannot work on the case, I think it's a good approach, because it depends on so many things. Another difficulty is also that when you accept an arbitration, you never know when you will have to work. Often you are approached by a party, will you accept to be an arbitrator? You say yes, and you don't hear anything before 4 or 5 months. So if you say, well, I cannot accept because I have no time, it is possible that you will have time when the case arrives. So I think it's more being. I think if you cannot trust the arbitrator to say whether he has availability or not, you cannot trust that person for many, many things.
Okay, thank you. Let me change gears now, Yves, to publication of awards. Investment in state arbitration, we see a jurisprudence, a case law, because all awards are become public. And of course, this trend end up reaching the international commercial arbitration that we see today. How do you see the publication of awards as a whole, especially in the international commercial setting, because it's different from the public involvement in the investment in state arbitration? How does this notion of publication coexist with the right to privacy and confidentiality the parties seek when they go to arbitration?
Well, what is important first is to note that since the ICC has launched this idea of publishing awards with the party's consent, I mean the parties may opt out the system of publication, about 50% have refused the publication. So it's not so bad, I would say. Half of the party see no problem with that. I think it has a certain advantage because it shows to the parties what the arbitrators are doing. It doesn't have the advantage that you have in investment arbitration, because in investment arbitration, in fact, the arbitration awards are creating in great part the law, which is to be are contributing to the development of international law. This is not the case in most commercial arbitration, where the arbitrators will apply a national law. So they don't add anything. They don't add anything to the content of the law. They just apply the law as it is, or at least they should. So I'm not sure that the interest is very, very big. I think it is positive. And if the parties agree, it's better that the parties, when in the future they will choose an arbitrator, they will be able to see whether that arbitrator is able to write a well-reasoned award I think that's good. I see a possible disadvantage, which is that it may push some arbitrators to make dissenting opinions, because many arbitrators some arbitrators, many it's too much, some arbitrators who doesn't agree with the solution will prefer to have the parties know it, and they will issue a dissenting opinion, while now if an arbitrator does not say that he's dissenting, or doesn't say that he disagrees with the solution, nobody will think that he agreed necessarily. The award may be done by majority, and that's all. For instance, I remember 20 years ago an award in a big construction case where there was about 50 claims. And I was the president. My two co-arbitrators were not very, very independent. And the result is that the decision on each of the 50 claims was made by majority. But the majority was never the same, because it was depending on the party who was benefiting from the decision. But at the end of the award, we just wrote, this award is made by majority. Nobody knew exactly who was how was composed the majority, although it was not very difficult to understand or to deduct. But I think now probably more arbitrators will be tempted to make a dissenting opinion. I'm not sure that it is necessarily good. It really depends why the dissenting opinion is made. If it is just to show to the party which appointed the arbitrators that you have done your job correctly, I don't think it is positive.
Yeah, I agree. One thing is to disagree on a specific issue of law, but the other one is to some sort of provide a message criticizing the fellow arbitrators. So this is something I would say, this is a sensitive terrain, a sensitive issue. Let me then go to the since we talked about the dissenting opinion, since we talked about the publication of awards, let me go one step further and see and discuss the role of the national courts. In the role of national courts, mainly after the award is made. We know national courts can intervene prior to, or the beginning, or during the course of the arbitration. But what are the current challenges of international arbitration, Yves? And I was writing here the following: in a more global scale, is arbitration in the need of obtaining greater support and better understanding by local courts, nation or global wise? So, because we've seen so many set aside proceedings, vacatures, I think these sort of set aside proceedings, they are on the rise. But what is the problem there? What is the challenge there? How can you cope? How can you address this issue in a way that arbitration remains its way to develop, but at least and at the same time see a better understanding from local courts?
Well, I think it's very difficult to generalize. It depends very much on countries. But I would agree with you that after years of increasing support to arbitration in many countries, now you get the impression that the pendulum is going the other way. And why, I don't know exactly. Maybe in a number of countries, the control was insufficient, and now it becomes excessive. If you take, for instance, the issue of the violation of public order, not public order, mandatory laws or ordre public in French.
Public policy.
Public policy, exactly. That's what I wanted. Was looking for. In France, the court were to the point where they said that they can refuse the enforcement of an award or annul an award if the violation of public policy is apparent on its face, which I think was going really too far, because if reading the award without entering into the case, you don't see the violation of public policy, it becomes absolutely impossible to control anything. So now we are getting in the other direction. And now the French courts have a different approach. They say, well, when public policy is at stake, the court may review the full case. So the pendulum went from an excessive point to an excessive point, and I have the impression that we are going in that. That's a trend which is the same in many countries, although it's not completely true what I'm saying, because if you see what happened in Spain during the 5 last years, it has been exactly the contrary. You have been an excessive control of public policy, and now it's become more reasonable. So I would hesitate to generalize. What I think is that there is a continuous need for the arbitral institution, for the arbitrators to maintain contacts with the judges and to discuss arbitration with them, so that they really understand what it is, and that they don't think, as some of them do, that that's arrangement between the parties or things like that.
Yeah. This reminds me when I started my studies and my practice in international arbitration more than approximately 20 years ago, or even more. My U.S. friends, they tend to say, "Oh, Latin America, they as a whole, is Latin American countries, as far as arbitration is concerned, is the same." And we see today countries in Latin America, they have different developments, different approaches from the court. So we cannot say, well, this is a trend in Latin America, this is a trend in that region, etc., because countries, they have developed arbitration, domestic arbitration, international arbitration, in a way that makes more sense for that particular jurisdiction. So I agree with you that this is something that we have to review case by case, or court by court, or country by country in a better way. You've mentioned public policy, and this takes me to a more general, very general question regarding New York Convention. And my question now, Yves, is something like this. Imagine that New York Convention can be amended easily, which is absolutely untrue. But just for the sake of our discussion here, if New York Convention can be amended after this 60 years, what would you see that could be amended, or there is no need for any amendment?
I think one of the amendments which should be done is Article 5(1)(e),
Okay.
which if I'm not wrong, if I remember correctly, says that the award may be set aside if it has been set aside in the country where it was done, without considering the reasons why it was set aside in the country what it was done, because we have seen many abuse of that. Award annulled in countries where we have no democratic system, no free judiciary, and the judge in the country where enforcement is sought are obliged to refuse the enforcement. So I think some solutions should be found. For instance, the solutions which exist in the European Geneva Convention of 1961, which introduce exactly the same grounds for refusal of enforcement as the New York Convention, but says that enforcement will be refused if the award has been annulled at the seat of arbitration for one of the reasons which are in the convention. And in that case, the judge will not check what have done the other judge. He will accept what he has done, but the reason has to be there. It must be nullity of the arbitration clause, something which is not just a peculiarity of the local law. And I think that's the more important. I think also that probably the reference to national public policy, which is mentioned in Article 5(2), I think, if I remember correctly, should probably be modified to deal with international public policy.
Interesting. Yeah.
I really don't. No, but why? Because I don't think that if you have an arbitration between, let's say, a German company and a Brazilian company, and enforcement is sought in France, I don't think that the award should be, the enforcement should be refused if there is a breach of French national policy, which has absolutely nothing to do with that case. The award, let's say, is enforced in France just because there are some bank accounts in France. But the economic operation has nothing to do with France. The law applicable is not French law. Why to refuse enforcement just because some rules which are of public policy in France and they are not part of international public policy should apply? Obviously, you have a way to out of this problem to say that this French rule does not apply to transaction, but no all judge will accept that. So I think this should be modified. That's the 2 points for me which are important.
Yes, and I'm glad you raised that, and I thank you for raising that, because you just touched on the Article 5, which deals with the recognition enforcement, which at the end of the day is where the award shall be recognized and enforced in the international community. And your comments also make me think one of the very interesting article that Jan Paulson once wrote regarding the, as he mentioned, the local standards of annulment vis-a-vis the international standards of annulment. So to avoid recognition of a foreign arbitral award should be focused more on the international standards of annulment.
I agree. That's more or less the same idea. Yes.
Yeah. And okay, so Yves, since our time is unfortunately about to finish, but I'd like to ask if I may, and if Lauro allows me to make those two further questions, in a very brief way. One is if you have any comments regarding COVID or post-COVID or post-pandemic in terms of arbitration. Are we going to enter a new normal in terms of hearing? So is there anything that you want to touch? And second, if I may, second is if you can, what is your hint to the young generation who wants to be more involved with international arbitration? These are my two final questions. Unfortunately.
Okay. For COVID, I think it will remain something, which is the use of virtual hearing, I would say for small hearings. You will never have, let's say, a conference for signature of the terms of reference discussing procedural order number 1 in person. This will, I think, will be always virtually, unless people are in the same city. But otherwise, I think small hearings, small meetings, less than 3 days probably will be virtual. And I think that's reasonable. Maybe also during these almost 2 years, people, because of the difficulty to conduct virtual hearings, have limited the number of witnesses. They have been keen to focus more on the important subjects, and I hope they will keep doing that, even for in-person hearings. Advice to the young generation, that's difficult. What I think, my advice is that, and I always say that to people, young people getting into my law firm, what is important, ever you are an arbitrator, ever you are counsel in arbitration, is look for the facts. You decide on the basis of the facts. You win a case on the basis of the facts. The law obviously is interesting. You have to be able to deal with it, but all your dedication must be in the fact. And for instance, when we are all the discussion about what an arbitral secretary can do or not do, people are talking about drafting the award of not or not. For me, it's not the point. What is important is that the arbitrator should see the document himself and not let somebody explain him what is in the documents. That's the only way he can make up his or her mind. And then if he write himself or he tell the person writes this, for me, that's the same thing. But the decision must come from the arbitrator, and to have a educated decision, you have to go directly looking at the documents. You don't let anybody to do that. Well, if the secretary wants to look at them, that's very good. You can even talk with him about the document, but you must read them yourself.
Excellent, Yves. Let me make my comments on those two answers. One is my biggest challenge today with the virtual hearing is called time zone. Depending on the amount of witnesses or the location of counsel, it creates some challenges to start the hearing in a way that is comfortable to everyone involved. As far as the hint to young generation, I very much appreciated your suggestions, because what I can see today, the young generations, they are very quick. They want to get the results very quick. They think they go to a cell phone, they Google, they do this, and they get bingo. They get the solution. Read the facts. Study and read the facts. That is a very important hint. Thank you very much, Yves. It's been a pleasure to speak with you, to learn with you. And unfortunately, we have to finish. But I look forward to having more of this conversation with you in the future. Thank you once more. Lauro?
Thank you. Thank you very much, Mauricio, for your question, which allowed me to think a little bit more than I did so far.
Thank you.